Hello, everyone. This is John Bodette with Employment Screening Services, and welcome to an employer's essential review of the FCRA. At no time in the 40-plus year history of the FCRA has there been as many enforcement actions and one-party and class action lawsuits for non-compliance as there have been in just the last several years, and there's no sign of it slowing down. The unfortunate part is that the vast majority of these actions would not have been brought if the employer had a basic 101 understanding of their obligations under the FCRA. If you play a part in the background check process within your company, I think it is essential to review these obligations. And as you go through the series, I encourage you to think about others you work with and communicate with about your background check, but who may not be directly involved in the process and therefore not familiar with the obligations under the FCRA. These people may need some FCRA education as well, so everyone is on the same page. Let's take a quick overview of what we're going to be covering in the three-part series and the questions I hope to answer. Today, in part one, we are going to briefly cover how the FCRA pertains to employment background checks that you do, and then take a close look at why there has been such a spike of legal action for non-compliance with the Act. In part two, we'll review the certifications that the FCRA requires employers to make before requesting a consumer report, but we'll primarily focus on one of the main reasons for legal action, the FCRA disclosure. And in part three, the longer part of the series, about 40 minutes, we'll tackle the other big reason for lawsuits and enforcement brought against employers for non-compliance, and that's the FCRA adverse action step. We'll cover exactly what the steps entail and when they are required. And when it reaches the point of doing a background check, we know that you need to fill the position as soon as possible before you lose candidates elsewhere. So I'll present several different scenarios and share a few ideas on how the adverse action steps can be implemented in a smooth and as timely manner as possible. First, as always, we must run a legal disclaimer. We always want to freely share information about employment background checks and be available for questions and clarifications. But we do need to emphasize we are not attorneys and we are not giving legal advice or opinion. In fact, I hope that no one takes my word on any of this, but rather, if you finish the series and feel your company may have some legal exposure under the FCRA, my goal would be for you to make it a priority to discuss and review these issues internally and as soon as possible. And please check with your legal department, especially with an attorney who is experienced with the FCRA, before changing any practices, policies, or documents related to employment background checks. Well, okay, now a very brief overview of the FCRA and how it pertains to employment background checks. It was created for one purpose and one purpose only, and that's to protect consumers. Back in the 1970s, when the law was passed, and even in later amendments to the law, Congress didn't put much thought into how employers would implement FCRA obligations into their hiring process. And not foreseeing the advent of the internet and the digital age, I don't think anyone could have predicted that the FCRA would affect as many people as it does today. But in fact, under the definitions in the FCRA, when an employer uses an outside agency to provide a background check for employment purposes, they are turning job applicants and employees into consumers. And you'll notice that when we talk to you about applicants and employees over the phone or in email, we may refer to them as consumers if it is within the context of the FCRA and consumer report. So who's the main players in the FCRA as far as employment screening is concerned? Job applicants and employees are not your normal consumers, a person who purchases goods and services for personal use. Let's take a quick look at how employers and their applicants and employees fit into the definitions in the FCRA. A consumer reporting agency, any person, and person could be person or business, for monetary fees regularly engages in assembling or evaluating information on a consumer for the purpose of providing a consumer report to a third party. Note that it's quite a broad definition, and it doesn't just point to credit bureaus or entities that deal with credit report, credit worthiness. A consumer report, any information from a consumer reporting agency bearing on a person's eligibility for employment, promotion, reassignment, or retention. Now, this isn't a full definition under the Fcra. A consumer report can serve different purposes, including the one we think about most often, determining creditworthiness from a credit report. That's one type of consumer report. But I wanted to emphasize that employment purpose is also specifically cited in the Fcra as one of the permissible purposes for obtaining a consumer report. The end user, that's pretty straightforward, any individual or entity that pays the fee to obtain a consumer report. And so employers become an end user when they pay that fee to a company that meets the definition of a consumer reporting agency and obtains information that fits the definition of a consumer report. And then consumers, those are the subjects of the consumer report, in our context, job applicants, employees. However, the FTC, which is one of the FCR regulators, has taken quite a broad perspective on the definition of employment purpose within the Fcra, and said that if you were obtaining a background check from the same type of source, the CRA, and the same Fcra disclosure, written authorization requirements, the same adverse action rights, privacy protections, etc., should be afforded to temporary workers, contract workers, interns, volunteers, or maybe even prospective board members that you were doing background checks on. And this will come up later, especially in Part 3 when we're talking about adverse action. All right, so it would have been much less confusing if Congress called it the Fair Consumer Reporting Act rather than Consumer Credit Reporting Act, since credit report is but one type of consumer report. And this is backed up by legal opinion and court decisions. So it doesn't matter that you may be using a service to just check a public record, take a reference, or verify a degree, something you could have easily done yourself. If these definitions fit, you are likely obtaining a consumer report. And that is likely true even if you're using a service such as one of the many online databases that may not even consider themselves a consumer reporting agency, or they may have disclaimers on their site that state they are not one. However, an employer who uses a service to help screen or evaluate applicants and employees would likely be viewed by the FTC as an end user of a consumer report. And so, well, the exception would be if you, as an end user, are working and getting information directly from a government agency, such as a court or DMV, for example. The Fcra says government agencies are not consumer reporting agencies themselves. But if you pay a third-party service to obtain that same information for employment purposes, then the Fcra is likely to apply. All right, so let's touch for a moment on why so much Fcra non-compliant legal activity has taken place in the last several years, especially since the Fcra has been around for 45 years, and employers have been doing background checks for decades now. So while nothing has changed in the Fcra itself for many years, the percentage of employers using background checks has consistently grown, and currently over 90% of employers do some kind of background check on their applicants and employees. They're easy to do, they're getting easier and easier to integrate with your other HR processes, and the benefits of employment background checks are clear, as are the risks of not doing them. So as a result, that's a huge number of background checks being performed each year, and they're growing right along with that number is the consumer's awareness of the understanding that of the employers and the consumer reporting agencies' obligations under the Fcra. So as a result, non-compliant employers and CRAs are drawing more and more lawsuits and enforcement actions for violations in the We have two federal agencies looking closely at the employment background check industry. The Federal Trade Commission has traditionally been the federal regulator, and more recently the Consumer Financial Protection Bureau has been given some enforcement authority. And the CFPB actually is just getting started at looking at CRAs and their end users and the use of background checks. So far, their primary concern had been looking at consumers' rights within the financial and securities industry. But the main push behind the dramatic increase in FCRA litigation, private employers. It was like a new frontier of green pasture just opened up in front of their eyes. A lot of background checks means a lot of potential plaintiffs. They just have to find them. And once a plaintiff's attorney is on the trail, that leads to an employer who has been out of compliance with the FCRA, even if it's just some small, seemingly innocuous technical violation. It's been said to be like finding low-hanging fruit for them, just ripe for the picking. So why? What's causing them to be so aggressive? One reason lawyers are going after the FCRA technical violations, like Winnie the Pooh goes after honeypots, is that there is a potential for a big payday with minimal effort. You'll note the $1,000 per violation in the on the screen there, and it may not sound like a lot at first, but if you multiply this times how many job applicants and employees were given, say, non-compliant documents over the years, or applicants who have been treated in a non-compliant way when they are denied a position, then this can add up quickly. And if there is a proof of willful non-compliance, in other words, you could have known, so you should have known, and that definitely is the case with the FCRA, because keep in mind, all end users, all employers of using consumer reports have signed an agreement to follow the FCRA. So if there's proof of willful non-compliance, then there are possible punitive damage under the FCRA, and there's no cap. And the kicker on top of all of that, if there is proof of willful non-compliance, the plaintiff attorney does not even need to show proof of harm to a consumer. And this was backed up by the Supreme Court in 2007. If there's proof of harm is not a requirement when there is proof of willful non-compliance. Now that could open up a lot of honeypots. So a second reason why the FCRA technical violations are turning the heads of many litigators is that very minimal time is required to bring a case. Comparatively anyway, not much need of discovery, investigation, and preparation, not a lot of research or interviewing witnesses or finding experts for the case. Usually class action suits eat up a lot of time just trying to get standing as a class action. With the FCRA and its technical violations, they're pretty cut and dry. The employer agreed to follow the FCRA. Either they did or they didn't. The evidence is usually well documented in their application materials and their written procedures that have been used for years. So the FCRA is perfect for class action. Potentially large pool of plaintiffs, very little preparation, and thirdly, employers are generally very willing to settle. I understand all of this, and it makes sense. Laws are meant to be followed and enforced, and it's one thing if an applicant or employee has suffered harm due to negligence by someone in the background check process, that person is due some reparation. But it kind of bugs me that when there's no proof of harm to anyone, that they are still able to troll the countryside and find something as small as, say, an extra couple of words in a disclosure that nets them a settlement of millions. And I had a slide in here that kind of displayed my feeling about those type of lawyers, but I decided it was in poor taste and unprofessional, so I decided to, wait a minute, sorry about that, somehow that was got back in there. So moving on. One way employers are finding plaintiffs is for the FCRA lawsuits is simply by advertising, just by going places where employment applications are being advertised, the newspaper, so forth, and they've been networking and collaborating with other law firms across the country since Many employers are multi-regional and they need help finding plaintiffs across the country. Some firms have been out there doing seminars and webinars, both geared towards other law firms, how they can sue employers and CRAs, as well as consumers, job applicants who have been denied a position due to a background check. Here's just another area where advertising takes place by employers looking for plaintiffs, one on Craigslist. And there's also evidence of phony applicants out there, either acting on their own accord or being put up to it by a law firm for people to apply for jobs and look for ways in which the employer did not comply with the Fcra. And so that's a fairly recent headline in the National Review. So I hope I've made the case that it would be well worth your time to review your position on the Fcra and your compliance obligation. In parts 2 and 3, you will clearly see that huge multinational companies have been targeted first. Since the more people involved, the bigger the possible class action. However, as the big companies get wise and get all their ducks in a row, and as more and more plaintiff attorneys want in on these easy paydays, and there is definitely a copycat effect taking place in the profession when they see successful settlements. Well, the combination of these means the target on the backs of smaller and mid-sized companies is going to grow bigger and bigger. So in the next 2 parts, we'll discuss the primary reasons employers have landed in Fcra hot water, and we'll talk about ways you can remove that target from your back. Here are some list of sources that will also be included in the next 2 parts if you would like to get more information about the Fcra and your obligation. The FTC and the EEOC, which often overlap in some of their responsibilities, published a joint document on what employers need to know. That would be a good one. There's the Notice to Users of Consumer Reports, which the FTC requires CRAs give their employer clients. The FTC's 40 years of experience with the Fcra, that's a very detailed look with very good commentary on the different sections of the Act that pertain to employers and CRAs. Number 4 is the EEOC's guidance to employers on the use of criminal records. I would consider that a must-read for anybody who, on behalf of their company, is conducting background checks or involved in the decision-making processes. And the EEOC also put one out geared toward applicants, what applicants need to know about background checks, so you can see what they're being advised, how they're being advised. And then lastly, on our IRIS website, the ESS Internet Report Access System, there's information available in our Resource Center under Download Forms. You'll find a lot of the information we're talking about in the next 2 parts, as well as other useful information. So I hope you go through the next 2 parts and let us know if you have any questions. Again, we cannot give legal advice, but we'll always help in any way we can. So thanks everybody for your time.